Good afternoon, everyone. Thank you so much for joining us for the third commercial bankruptcy program in the NCBJ Behind the Bench series in collaboration with the ABI. My name is Alyssa Castaneda. I'm a partner in the Finance and Restructuring Group at Dorsey & Whitney here in Phoenix, Arizona. We are very excited to be discussing the Phoenix Coyotes, now Arizona Coyotes, Chapter 11 case today. A couple of quick administrative things to mention. If you want to send any questions to the panelists during the webinar, please use the Q&A feature to do that. I will be monitoring that. It'll be only visible to the panelists. If you would like to use the chat feature to talk among yourselves and with the other attendees, please feel free to do that during the webinar as well, but we will not be monitoring that. It's my pleasure to introduce the panelists to you today. Each of them played a key role in the Coyotes Chapter 11 case, which was filed in the Arizona Bankruptcy Court in May 2009. At the head of the table today is the Honorable Redfield T. Baum, who's the presiding judge of the Coyotes case. Judge Baum has served as a U.S. bankruptcy judge for the District of Arizona in Phoenix since 1990. Judge Baum has been an active member of the NCBJ, serving on the Board of Governors and several other committees over the years. He served multiple times as a judge pro tem on the Ninth Circuit Bankruptcy Appellate Panel. Judge Baum was one of 3 members of a U.S. delegation to the Czech Republic to assist and consult regarding a new modern insolvency law in the Czech Republic. Judge Baum also helped create and implement the Alternative Dispute Resolution Program adopted by the Arizona Bankruptcy Court. Right next to me is Tom Salerno. He was counsel for the debtors in the Coyotes case. Mr. Salerno is a partner at Stinson, LLP in Phoenix, Arizona. He's a 40-year practitioner who advises distressed companies, lenders, committees, and asset purchasers in bankruptcies and out-of-court settlements. Mr. Salerno has international insolvency experience, including advising numerous foreign governments on revamping their insolvency laws. He currently teaches a class on Chapter 11 bankruptcy with Judge Baum at Arizona State University College of Law. And no surprise, he's also a contributor, along with Judge Baum, to the Collier's chapter on sport team special insolvency issues. Across the table from me today is Susan Freeman. She was counsel for PSE Sports and Entertainment, one of the prospective buyers and stalking horse bidder in the Coyotes case. Ms. Freeman is a partner at Lewis Roca in Phoenix. She focuses her practice on commercial bankruptcy and all types of civil appeals. Ms. Freeman has represented a wide range of clients in Chapter 11 cases, including debtors, trustees, secured and unsecured creditors, committees, and asset purchasers. Susan has briefed over 300 civil appeals and argued over 100 of them, including one before the U.S. Supreme Court. Ms. Freeman was the first lawyer and now only one of 2 lawyers to be invited to membership in both the American College of Bankruptcy and the American Academy of Appellate Lawyers. And next, Alan Maida was local counsel for the National Hockey League in the Coyotes case. Mr. Maida is a partner at Birch & Crocchiolo in Phoenix. Mr. Maida has almost 40 years of experience, and his practice focuses on representation of creditors, debtors, committees, and trustees in Chapter 11 reorganizations, workouts, liquidations, and related litigation in Chapter 7s and 11s. Mr. Maida also represents clients with respect to loan financing, purchases, and transactions. Mr. Maida has served as a Chapter 7 and 11 trustee and a plan agent in several cases. So I'm going to set the scene very briefly here. It's May 5th, 2009, almost 13 years ago now. NHL Commissioner Bettman and Deputy Commissioner Daley were on their way to Arizona to present an offer to purchase the Coyotes. A few hours before they arrived, Dewey Ranch Hockey LLC filed a Chapter 11 petition. So let's turn to our panelists now and get started. Tom, as counsel for the debtors, you obviously started with evaluating several options before you decided to file Chapter 11. Can you tell us why you did and what your primary goals were in doing so?
Well, Alyssa, thank you very much. We had a fairly straightforward business goal here. What we needed to do was sell a team to a buyer that had not been approved by the NHL to allow the rejection of a multi-million-dollar year lease with the city of Glendale, relocate the team internationally 2,500 miles to Canada, and to do so, said May we filed, to do so before the start of the NHL draft in June, with the hockey season starting in October. So it was a pretty straightforward, simple business proposition. Clearly, the Coyotes had explored a number of different options beforehand. The one that we really wanted to do was to get the NHL to approve a sale to a buyer. We looked very far and wide for a buyer that would keep the team here in Arizona, because that was the NHL's certainly preferred choice in the matter and their preference. And the only one we could find ultimately that would maximize the value was PSC, Ms. Freeman's client. But a condition was, of course, that they are able to move the team to Canada, where people actually go to hockey games. And so you had a team that was bleeding cash. The Coyotes moved here in 1996. They have never made an operational profit in all the years they've been before the bankruptcy and since. They've just never made any real operational profit. And Mr. Moyes and his various entities, who were the ultimate owners, had dumped easily $100 million plus of their own money into keeping the team going. And they had just they'd had enough. The NHL, in addition, had lent money to the team to keep it going before the bankruptcy, and they simply had enough. And so while we talked to the NHL about selling the team, in particular to someone who was going to take it out of state, because that was the interest, we were told in no uncertain terms by the NHL, you are to discontinue all discussions with anyone that will do anything other than buy the team and keep it here. And even then, they wanted, obviously approval rights with respect to that. So
and the losses were staggering, as I recall, something like $30 to $36 million a year.
A year, exactly. Oh yeah, a year. A year. It was incredible. The losses were incredible. To keep this team alive was just eating money. It was just eating money. And at the end of the day, it was decided that perhaps the simplest thing to do, not the simplest thing, but maybe the only thing that we could do at that point, given the lack of other interested buyers to keep the team here, was to do something that at the time only 7 other teams in the history of the bankruptcy code had done, which was file Chapter 11. So we became, I believe, the 8th, I could be wrong on the numbers, the 8th or the 9th team that filed bankruptcy in order to ask a bankruptcy judge to do the things that I had mentioned are straightforward, what I still believe was a straightforward business proposition through the bankruptcy. And we had to do it on an incredibly short timeline because of the nature of the purchase offer, the nature of the losses with the team, and the fact that we were going to have a buyer that was going to pay a lot of money, $250 million for this team, and they weren't going to stick around forever.
So let's talk about venue for a minute, because this case was obviously filed in Arizona. Why was that decision made?
Well, there were only 2 real venues to file this team. One was Arizona and one was Delaware, because the actual entity that owns the Coyotes is a Delaware entity, a Delaware LLC, I believe. So we looked at these 2 options. We did a very in-depth analysis, which wound up getting leaked inadvertently to the NHL. And I'll certainly leave the NHL to discuss that, leave Mr. Maida to discuss that. But ultimately, it was decided we would file it here in Arizona. The biggest concern we'd have if we went to Delaware to file this, that the Delaware court would look at this and say, this is really almost purely an Arizona issue, and kick it back. And if that had happened, we would have gone into a wheel, so to speak, for a random assignment. So what we had done, being totally candid, we created an entity called Dewey Ranch Hockey, which was based in Dewey, Arizona, because there was in fact a ranch owned by the owner. Dewey Ranch Hockey was created, 3-4 days before, and I just know the ink was dry on the actual formation documents when we filed it. We filed that. That was assigned to Judge Baum, because at the time, under the rules, he would get these cases. We then consolidated the other 3 entities, there were a total of 4, under Dewey Ranch Hockey.
So effectively, you're choosing the judge by virtue of choosing the venue, the little town in northern Arizona.
I think some might call it judge shopping.
Ouch, ouch. So Judge, let me ask you something. Something in first day hearings, of course, there's a motion for joint administration. And we all know how controversial those are. And you actually said you were going to give parties 5 days, I believe, 5 days to file an objection to joint administration. What would ever possess you to do something like that?
Well, you have to put this case in perspective. I like to look at it this way. If you go back to the John Mansfield case in New York in the early 1980s, after that, in 2009, this was one of the most bold, bodacious, brazen, and brash efforts to use Chapter 11 in the manner that they did. And I think you have to mix in a little bravado and bravura in with that, because it was just an incredibly unique case. And I don't think when the case was filed, any of the schedules were of record. So I didn't know Dewey Ranch Hockey from Coyotes hockey or anything, but I wanted to make sure everybody had a fair opportunity if they wanted to challenge something to do it. And you have to kind of lay the perspective of the start of it. Ms. Freeman was nice enough to call us before the first hearing and say, one courtroom will probably not be big enough to accommodate everybody. So we actually had a second courtroom that we used with an audio video feed so everybody could hear and listen to what went on in the courtroom. And then I'm not sure how many phone lines the bankruptcy court had at that time. I think it was about 50. And I was told after those first day hearings that collectively all the people calling in so they could listen to the hearings, there was no other phone line available at the bankruptcy court that day. So if you had another case and you needed to get through, you couldn't. And so we had to right away after that put some limits, particularly on the Skadden firm in New York City, how many phones they could use to call in with. And it was just a very, very unique case.
And Alan, I wonder if I could ask you, being on the other side of the table from that, both here and in the case, the NHL never made an issue of venue. Are you at liberty to tell us about your ideas on that?
Well, I don't think there was any, there's no surprise here. This was an obvious attempt to handpick the judge for this case. That was very clear to us. But at the end of the day, you have to consider the uncertainties of who might be selected if it went back to the wheel. And ultimately, we were comfortable with where we were, the state of the state, and made a conscious decision that we weren't going to object. I would also just like to add that, from the NHL standpoint, this bankruptcy never should have happened. And that's, you mentioned about Mr. Daly and Mr. Bettman being on an airplane. They were actually on their way out here, as you said, to present an offer to the Coyotes that would hopefully solve the financial challenges that the owner was dealing with. And there was also an issue that came up early in the bankruptcy case relating to authority to file bankruptcy and proxies that had been entered into by the owner in, I believe, November of 2008 that the NHL believed gave the NHL the right to control the club. And so, and in addition to those authority issues, the NHL was actually funding the operations of the hockey club going back to, I think, November of 2008. So, they were funding the club before the bankruptcy. The NHL was funding the club after the bankruptcy.
It didn't want us to fund it.
And,
We tried.
from the NHL standpoint, this was never about the creditors. This was never about paying creditors. This was all about maximizing the value of the owner's equity interest in the hockey club without the consent of the NHL.
Well, this is kind of what Chapter 11 is about. I mean, it is about maximizing value. I don't mean to be that guy, but that is kind of the point of Chapter 11 is to maximize value. But I can understand why the NHL might take issue with it.
And
It was
the owners
bodacious.
did have some pretty significant debts, indebtedness that was owed by the team as well. And one of the other big creditors was Wayne Gretzky. And the NHL didn't want him to be paid.
Well, the NHL, that wasn't necessarily true. The NHL wanted all legitimate creditors of the hockey club to be paid. Unfortunately, Mr. Gretzky's contract was with Mr. Moyes directly and not the hockey club. And that's why Mr. Gretzky wasn't paid out of the bankruptcy.
So
He is
I-
only the
I-
greatest hockey player of all time. But other than that,
I think it should be added that he in effect is the Babe Ruth of the National Hockey League. And I have to admit, and I think I expressed this several times from the bench later on in the case, I was really, I think, stunned at the NHL's treatment of Wayne Gretzky because of who he was. But, everybody has to take their legal positions as they think in their best interest.
the other thing that was filed shortly after the filing is an adversary proceeding, and this became a necessary component. The adversary proceeding sued the NHL for breach of antitrust laws, for violation of antitrust laws on the basis of the league's control over where teams played. And that became a necessary component, of course, because under the ultimate legal theories, which I know Ms. Freeman is going to get into in a little bit, but in order, there did have to be a legitimate dispute about the claim of the NHL and the ability to sell free and clear of restrictions that were in the operative documents and the NHL Constitution. And therefore, a antitrust lawsuit was filed along with the filing in order to prosecute those claims and create the legal niche, if you were, that we would use to seek the relief that we did.
So the basis of that is that in the NHL Constitution, members have a right to a home territory, and their home territory extends 50 square miles beyond I think it's not beyond the
arena,
the arena, but it may be also the city basis. So Hamilton, where our client wanted to relocate the team, is 43 miles away from the Maple Leafs arena in Toronto, 7 miles inside their home territory. And under the Constitution of the NHL, each team has a right to veto any other team coming into their territory. And that is the same kind of veto that actually came up in the Raiders case in the Ninth Circuit. And the Ninth Circuit held that that was an antitrust violation. And when the Oakland Raiders were trying to move to LA, and the NFL tried to stop it, that was held to be an antitrust violation. And there was a 2 years of litigation and a jury trial and significant damages that were awarded and that were upheld on appeal. So what you have really is a determination, at least in the Ninth Circuit, where Arizona is located, that this kind of restriction should not be enforced.
It's interesting, the intersection between antitrust and sports leagues, because of all the major sports leagues, only Major League Baseball has an exemption from antitrust laws based upon some, 1920s, 1930s US Supreme Court decision saying baseball is so important to the American psyche that they created this judicial exception. But I know the NFL, there have been decisions where the NFL said, no, you're subject to antitrust laws. I don't know. I don't think there's one specifically for NHL or NBA, but I know that there was at least one decision which said the NFL is. Well, so it was kind of treading. We were creating new laws. As we were moving forward in this bodacious, which I took as a compliment.
You were kind of on the outer edge of what the bankruptcy code allows, and you had this combination of section 363, 365, and an overview of the antitrust laws on top of that. And the Skadden firm, I don't remember exactly how many lawyers they brought out to the hearing. A couple of times, I think they may have had 5 or 6 lawyers that not only were physically present, but were up at the podium arguing various aspects of their position. And their core position was pretty straightforward. Under all of their contracts, they control who can become an owner member of the National Hockey League. They have to approve a new owner. They control location. So you have the Arizona Coyotes based in Arizona. That's their geographical territory. And if you want to relocate, you have to file, to call it a detailed application is probably too much of an understatement. So that's the structure of the way their constitution existed in 2009. And then behind that, you had 2 pieces of litigation between the NFL and the Raiders, primarily on antitrust grounds. And I got to correct a little bit. The jury verdict that the Raiders won in the first go-around was set aside by the Ninth Circuit in the second go-around because the jury was not instructed about the NFL's right to a relocation fee. If you want to take LA, all right, that's our territory, not yours. So you have to compensate us for that. That's part of the damage calculation. And then at almost the same time, the then San Diego Clippers just up and moved to Los Angeles without the consent of anybody. And there was litigation about that. And all of that led to modifications of, I think, all the league's relocation rules and procedures. If you wanted to change your geographic territory, here's what you had to do that. And then all those cases stress this, that the NFL product does not fit at all within the typical antitrust scheme. So it's very factual intensive. It has to be carefully analyzed to figure out whether there really is a violation or not.
But the court in Raiders 1 was also holding that although a league can have collective action to determine schedules and to determine locations, there have to be reasonable rules-based criteria for making that determination. And the court said in Raiders 1 that some of the owners and the league commissioner thought that the proposed purchaser was a maverick. And so the decision was made on grounds of animosity instead of business judgment.
Well,
and we were saying that's really the same thing here.
Let's cut to the heart of it. Pete Rozelle, the then NFL commissioner, and Al Davis, the owner of the Raiders, to say they couldn't get along is an understatement. And if you're a sports nut like I am, there is now a 30 for 30 show after both men have died about how bad that relationship was.
So I think that at its core, this case really came down to 3 important rights that the NHL maintained it had. The right to determine who the members would be in the league, the right to determine where that member played its home games, and the right to a relocation fee. Those were all 3 rights, I believe, Judge, that you acknowledged in one of the orders. And we can talk about this a little bit later, but I think one of the problems that the Coyotes had in this case was figuring out how it could adequately protect those interests if it was permitted to sell the team to PSC and move that team to Hamilton.
But you only have to adequately protect if you're at the litigation stage and not at the final determination stage. And we thought sufficient evidence was being presented. And certainly, Judge Baum, you ruled at the first hearing that there was sufficient evidence that the determination of ownership, of whether PSE was a legitimate owner or should be approved as an owner, had been met. That you said that here, that the NHL cannot object or withhold its consent to PSE becoming the controlling owner of the Phoenix Coyotes unless you show a material change in circumstance from when it was approved in 2006. So you indicated that there was really no basis for thinking that PSE would be disapproved as an owner if it was willing to keep the team in Glendale, and this was really all about relocation.
But those changed circumstances were demonstrated.
No, not before 2006. They were, well, the only thing after that you raised was that they filed bankruptcy
Well,
or participated in the bankruptcy.
you know, the background to this case is fascinating. Because when it was filed in 2009, PSE had been approved, I think, twice. Once to buy the Pittsburgh Penguins, an NHL franchise, and then later the Nashville Predators, another NHL franchise. And I think we can say that the Predators were kind of round two of that. And at least the evidence from the NHL's perspective was things had gone badly between PSE and the NHL in relation to the Predators. But you had that background. Here's the buyer who's been approved twice to be an owner in the NHL. And so you have, at least from the bench, a lot of pause, but there's no question there were two fundamental issues in this case. Can you force a pro sports league to take on an owner that in effect they don't want? And can you force a relocation to another geographic area that they haven't approved? And I think when the case started in May of 2009, initially there'd been no application for a change of ownership or change of location for the Phoenix Coyotes. So it was an effort to kind of ram it down the NHL's throat from the get-go.
But Judge, in fairness to the Coyotes and under that, with not having the application, the NHL said, do not submit one. They said, do not submit. We will not entertain any change, any sale that attempts to move this team out of Arizona. So I'm not talking moving from Glendale to Tempe. I'm talking moving it out of the state of Arizona. So they were told in no uncertain terms, you can spend the time to do the paperwork if you want, but we're not considering it.
And effectively didn't consider it thereafter, as we can kind of get to.
I don't think it was ordered, but I think there were strong comments from the bench. Maybe those applications ought to be filed.
There were indeed, and they did get filed, and those were extensive. The application to become an owner had a lot about the owner's character, because in fact, the only grounds that are in the NHL bylaws for making a determination about the ownership are whether the person has sufficient character and whether the person has sufficient financial wherewithal to enable the team to be stable. And that's all that is supposed to be considered. And if in fact you're considering those aspects in good faith, PSE met them in spades.
Well, actually, the NHL disagreed and determined that PSE did not pass the integrity and character tests.
The first and only ever to do that, despite there being convicted felons in the league as owners.
Nobody's perfect.
I think what was a crucial part of that determination was the owner of PSE refused to acknowledge and agree to be bound by all of the underlying documents that govern the operation of an NHL team. And obviously, moving the team without the consent of the NHL, selling the team without the consent of the NHL, these are critical membership rights that every team is bound by. In fact, I believe early on in this case, there were briefs filed by the other sport leagues, the NBA, the NHL, the NFL, and the
Major League Baseball.
Major League Baseball all filed briefs highlighting the importance of the right to determine who the members are and the right to determine where those members play their home games.
Well,
But
Alan,
the
but
determination
Alan,
has to be made in good faith,
Yeah.
and that was the problem.
Well,
but Alan, but let's keep in mind as well, the NHL here cited no less of an authority for that proposition than Meatloaf. Because I will never forget, I love this, Tony Clark from Skadden, great guy. And he's arguing, and he said, Judge, owning a hockey team is like the Meatloaf song, 2 out of 3 ain't bad. You have to have 3 things. You have to have a lot of money, because it's a money intensive thing. You have to have a love of the game, and you got to play by the rules. And he said, PSC, a lot of money. PSC certainly had a love of the game. But 2 out of 3, and unlike the Meatloaf song where 2 out of 3 ain't bad, you need 3 out of 3 in order to become an owner. So they did cite the unassailable authority of Meatloaf for that legal proposition. So,
Well, in my first ruling on this point, the professional sports league's argument was, Judge, if you approve this, you'll wreak havoc in professional sports. And they drew a bad judge for that argument because I'm an old sports fan. And I asked their lawyer, and I said, well, help me out a little bit, because my memory is in the middle of the night, the Baltimore Colts packed up, not telling anybody, and moved to Indianapolis through Mayflower moving vans, which is based in Indianapolis. And the NFL survived that. The Seattle Pilots, an old Major League Baseball franchise for only a couple of seasons, were sold through the bankruptcy court in Seattle and moved to Milwaukee. Now, ultimately, Major League Baseball consented to that move. But initially, before the ruling, they did not. And oh, by the way, the owner of the Milwaukee franchise was a guy named Bud Selig, who was the commissioner of Major League Baseball at that time. And of course, I've already mentioned the Clippers and their surreptitious move. And at least from what I could see as a fan, all the sports leagues did just fine, notwithstanding that. So I really struggled with it'll wreak havoc in professional sports if you do this, Judge.
And I think it's important that the rules, the bylaws, the Constitution do permit relocation, do permit sales. It's just that you have to meet certain criteria. And that includes 3/4 of the then owners agreeing. But they have to agree in accordance with the criteria. They can't choose on arbitrary antagonistic grounds as opposed to the criteria that are in the rules.
You know, an interesting question that I don't think courts have ever confronted antitrust grounds or other ownership. And that is, can the league just say, no, we don't like this buyer, we're not going to approve the sale?
And that's where I think Raiders is helpful in terms of saying, no.
But Raiders was an existing owner. He was already an owner in the league. And I think one of the great questions that is out there is, can you force your way into being an owner in a professional sports league? And you know, it seems to me
because they have an obligation to comply with the rules in good faith. That good faith and fair dealing, as you said in your opinion.
but folks, this, when you think about it, Coyotes was filed in 2009. The time after the Coyotes was filed, you had the Dodgers filing, and you had the Rangers filing, and the Cubs. The Cubs was literally a 24-hour bankruptcy. But the issue you're talking about, Judge, came up directly in the Dodgers bankruptcy, where Judge Lynn, who is presiding over that, or the Rangers, I'm sorry, it's the Rangers bankruptcy, where Judge Lynn in Texas said, I recognize Major League Baseball has the right to do this under their documents. But if I'm faced with an issue as whether that right was exercised in good faith, I don't want to make that decision, but if I have to, I will. And that ultimately got worked out.
We've read the transcript of that hearing, and he put tremendous pressure on Major League Baseball. Well, what happened in Rangers and Dodgers is the two sports, the Major League Baseball and the debtors worked out a procedure where Major League Baseball pre-approved the bidders for both auctions, so that they accepted whoever was going to end up buying the franchise. And the Cubs was very unique. I'm not sure the Cubs per se filed Chapter 11. I think it was sold out of the Tribune case, and it was $800 million cash. And I think the Tribune creditors hey, we're happy to have $800 million. I think Major League Baseball said, we're happy to have the Ricketts instead of the Chapter 11 Tribune. So they didn't quite confront, can you force your way into a league over their objection?
Although, Judge, in the Rangers case in particular, that while Major League Baseball pre-approved the stalking horse bidder, what they did not approve, remember, you may recall that Mark Cuban was coming in and said, I want to bid, and they had not approved Mark Cuban. They approved the stalking horse bidder, which is the Nolan Ryan group.
Well, I thought they approved Cuban and the now owner of the Astros were jointly trying to buy it. And I think at a minimum, they signed off on the Astros owner.
They did, but not Cuban.
Yeah, and so they kind of finessed the, their right to pick who can own.
Judge, let me ask if I can, because we're talking about all these things, and these are huge. First of all, we're treading a lot of new ground. You're trying to say, oh, does this case fit into this? And it's not like we have a wealth of case law that we can say, okay, well, look, this is, we don't have that. You've got this overlay between antitrust law and bankruptcy law and contract law. And I don't think as long as I practice law, I will ever forget a statement you made from the bench. And I did take it to heart. And that's this. You had the NHL, and the NHL had lawyers that specialized in antitrust. That's what they did. And then you had your bankruptcy lawyers, and then you had your contract lawyers.
And the sports team lawyers.
Oh, yeah, yeah.
Law
And then you had.
They brought the whole thing.
They brought the whole thing. But same thing. We had antitrust lawyers. We had this, we had that. And again, everything has to be done yesterday. And so we'd stand up to the podium and say, Your Honor, if it's okay, when we're addressing the antitrust issues, Ms. So-and-so will address that. When we're talking about this, Mr. So-and-so will do that. And so that's how we divided up the work for arguments. But honestly, I don't think I'll ever forget this. And you said, well, you can have as many lawyers as you want presenting, but you need to keep in mind, there's just me. And it was an interesting comment because as caught up as we all get in the nuance, because you can call upon your antitrust colleague, you can do that. But at the end of the day, we're funneling it through a judge, and the judge is trying to absorb all of this information that no one lawyer in the courtroom probably, you have a handle on the things you do, but I'm certainly not an antitrust lawyer. I mean, I wouldn't pretend to be, and things like that. Was that, obviously it was enough that you mentioned it from the bench?
Well, I think I'll answer that somewhat indirectly. You have to start with this premise. I was blessed with great lawyers in this case. There was not a lawyer who didn't stand up and argue who wasn't a very good lawyer. And I realized out of the box the magnitude of this case. So I waived the page limit rule on all the briefs. Now, the downside of good lawyers in that ruling was I got buried in massive briefs. And here's what I did almost out of the box. I hate reading on a computer screen. So I said, I want paper copies of every pleading that you filed in 3-ring binders delivered to my chambers. And any case you cite, I want a 3-ring binder with copies of your cases. And if you're going to cite for example, the Alcoa antitrust decision, which I think is more than 50 pages long, why don't you highlight the portions that you really want me to read so I don't have to read 47 pages of meaningless stuff in relation to what I'm trying to decide. And I'll give the lawyers a lot of credit. They did a great job on that. The last big hearing was right after Labor Day. At that time, I had a place in Flagstaff, and I told them, and I said, deliver those to the security gate in Flagstaff for me, because I'll be up there and I'll be reading them up there. So if you want me to read them, that's what you need to deliver.
When you look at kind of the way the parties were aligned in that case, you obviously had the league joined by every other league. As you pointed out, they all filed amicus. You had the league, you had the debtor, the owner, and the buyer. You had that. You had the city of Glendale, which we haven't yet talked about, but the Coyotes played and will play up until I guess they're done now, right? But they played in an arena that was built by taxpayer money out on the west side of Phoenix. And it was a taxpayer-funded arena. And they played out there. It was a 30-year lease. We had to have 20 some odd years left on it at the time of the bankruptcy. And obviously, to the extent we were successful in selling the team, where the team was going to leave Arizona, we had to reject the city of Glendale lease, the arena lease. And so you had the city of Glendale, who was then aligned with the NHL because they both were going to keep the team here. And then you had the general unsecured creditors, which in some respects included potentially players, the players. But the people that no one was ever trying to mess with in the case ever was trade creditors. I mean, true trade creditors, what you would call the legitimate hockey team creditors. No, and no one was trying to mess with players. No one was saying, hey, could you take a 10% haircut next year, so we can make this team go. And so while the players union would show up, they weren't really, as long as no one messed with their contracts, they were fine. The trade, we had an unsecured creditors committee. In fact, it was represented by Paul Sala, now Judge Sala, in the case. But he had kind of you're watching because no one's saying, I'm going to pay you 5 cents on the dollar and make you go home. So really the battle lines as they were drawn, it was a three-legged stool, if you will, the debtor, the PSE, the city, and the NHL, who were kind of aligned as against the debtor and the owner. It was that was kind of the dynamic.
If you haven't been to Phoenix, and the hockey arena is right next to the Arizona Cardinals Stadium in Glendale, Arizona. And I know for a fact, the last time the Super Bowl was here, when some of the owners were driving from these very plush hotels in Scottsdale out to the football stadium, they have to go by farms with cows grazing in the pastures. And we're kind of stunned as to what was surrounding these arenas. And the point of all that, particularly for hockey, this was probably the worst location you could build a hockey arena. Why do I say that? Well, if you want to go to a weeknight hockey game, it's probably going to start about 6:30. You're going to drive home with all the going home traffic in Phoenix, Maricopa County, which is one of the most populated counties in America. And it's a road trip. If you go to a football game on Sunday, it's an all-day event. And so it's just a horrible location. And they've never recovered from that mistake. As of early this hockey season, Glendale and the Arizona Coyotes had it with each other. Glendale said this was the last year they'd let the Coyotes play there, and the Arizona Coyotes said, great, we're done. And so we went from 2009, where Glendale's fighting tooth and nail to keep the team in that arena, to 2022, where they're divorced. But there's still this very expensive arena out there that the city of Glendale, I think it costs $225 million to build. There's $180 million in bonds from the city of Glendale, and the team in Glendale invested about another $40 million to build.
I can tell you that we did make an offer to Glendale to buy its claim for $50 million, of which $25 million it would get even if the team was ultimately sold to someone else, just so long as they would stop opposing PSE buying the team. They refused to consider it. That was the last of several offers that we made. They refused to respond. Ultimately, I went out to a Glendale City Council meeting and was allowed only 2 minutes to make my pitch. And they sat stone-faced and completely refused to respond. I mean, and they were losing such enormous amounts of money. When you say the taxpayers funded this, they funded it through bond issuances, and they had to keep getting taxpayer money to pay the bonds on into the future. We would have saved them an enormous amount of money, and this was not a good place, and it was going to go anyway.
I will never forget this. At the start of the September hearing, Ms. Freeman stands up and offers the city of Glendale $50 million in cash, and I forget what the city had to do. And I turned to the Glendale attorney who'd been at every hearing, he's from Boston, said, Mr. Baldiga, would you like a recess in a few minutes to talk to your client about the $50 million offer? his mouth was speaking before he was out of his chair, and he said, "No, Judge, we're not going to take it. We don't need any time to think about it." And I have to tell you, I was stunned.
And this was just not, I mean, and the city council who made these decisions was displeased.
You know, when you compare and contrast, again, for those who've not been to Arizona where the Coyotes play is out, as the judge said, way out on the west side, and literally across the street is the Cardinals Stadium where the NFL team plays. And so the NFL, the Cardinals, as far as attendance, that's all fine. And you say, so why is that the case when the Coyotes don't draw as many people? And the big issue is the NFL plays how many home games? 6, 8?
Eight home games plus playoffs, but they're on Sunday.
Exactly.
So there's no traffic.
Or the occasional Monday.
Yeah.
But the point is, it's 8 games. And so when people make the road trip, it's not like, how long is the hockey season? It's like 100 and it's a lot of games.
82 games. I think.
82 games. So there's a lot of games. So it's one thing to make a road trip on a Sunday to go out there, and it's another thing on a Wednesday. It just becomes an interesting time
It was
drink.
downtown, when the Coyotes first moved to Arizona and they were downtown and they were playing in the Suns Arena. They still lost money. They still lost
Right.
tons
No,
of money.
I know.
You can't really use that because that arena really wasn't built for hockey and it had all kinds of problems.
And so
Oh, that
you
did.
get
That's
the
true. It
arena
did. It
with
did.
the bulb, and then you move to Glendale,
That
and the
arena was
arena's
so
fine.
bad, some of the
Yeah.
best seats had obstructed sight lines for the rink. And so you could pay a lot of money for these seats. If the puck kind of would go underneath where you were sitting, you couldn't see what was happening.
But then a new arena in Glendale doesn't do any better.
Well,
So I think part of it is that hockey is not a natural fit for the desert of Arizona. We play golf here, we play tennis,
Yeah,
we play basketball.
I'm
here.
I don't think we can
shocked that you
underestimate
could say
that.
I'm not buying that for a
You
lot
can
of
pay a
reasons.
ton of money.
You have 2 teams in Florida, you have a team in Dallas, now you have a team in Las Vegas,
Mhm.
and they're all doing well. So I don't agree necessarily that hockey can't survive in Phoenix. I think that the location of the arena was obviously an issue. I think you have to also consider the demographics of hockey fans in the Phoenix metropolitan area. The fact of the matter is that the hockey fans are in Scottsdale and in the East Valley. And that's quite a distance from Glendale.
I think that's fair. I mean, I think that's a fair point.
if you know the history of how Glendale came to be, the then owner of the Coyotes, this was before Mr. Moyes became the owner, was a developer named Steve Ellman. And he was well down the path of building a new arena in the heart of Scottsdale. It was kind of thought to be a done deal, and then somehow he and the Scottsdale City Council got unbelievably crosswise and antagonistic. And then the mayor of Glendale swooped in and said, "Hey, come out to Glendale. We'll put up $220 million to build you a state-of-the-art arena." And it is a very nice arena, but it's the old real estate. What are the 3 rules of real estate? Location, location, location. And this was a horrible location.
You know, when we look at the public nature of the case, it was not only of national interest, but international, given, the Canadian press. The Canadian press was all for the move, as you would imagine they would be, other than the Toronto Maple Leafs. So, the Canadian press tended to be very, very favorable in talking about it. But it is really extraordinary, a couple of dynamics, and I'd be interested in the views of the rest of the panel, which would be this. I mean, you're trying the case in the press. So as you're walking into the courtroom for every hearing, this was in the days before virtual hearings, you're coming in, and as the judge said, they set up an entirely separate courtroom, overflow courtroom for just the press so that they could see what was going on court TV, so to speak, because they were standing room only. But people are giving interviews going into the hearing. They're giving interviews coming out of the hearing. Dueling interviews are going on. But the press, in the press room, so to speak, there's people that are doing real-time feeds. So Twitter or blogs and things like that. And so while you're at the podium, you'll be saying the sky is blue. And your colleague at the table was the lawyer just argued sky is red. I said, no, that's not what. And it was the weirdest thing because you're getting these these real-time reactions without obviously any aspect of introspection or analysis, just because everyone's trying to get it out there sooner rather than whether it's accurate or not. Let's get it out there right away.
Did that impact how any of you approached your arguments? Because that's not something we normally have to deal with.
Yeah, I mean, it certainly didn't for us, because at the end of the day, the press, regardless of how the press ruled, we still had to get the person in the black robe to go with it. So, but it was just interesting to see. And very frequently in the case, and Judge will undoubtedly recall admonishing me for this, Gary Bettman would give an interview, he'd be quoted and he'd say X, whatever he said.
And so the NHL commissioner.
Yeah, NHL commissioner. And so we'd stand up and say, Your Honor, the NHL has taken the position X, and here's newspaper article and, Sports Daily or whatever. And the newspaper article is not evidence. Let's kind of get past this, because you could use, there were just press releases and everyone was going crazy in the press.
I think short of an order, I try to admonish everybody. It's meaningless to me. So I know you go out there, talk to the press, then you attach the article that supports the view you gave the press in your next brief. I mean, come on, give me a break. But it's just another unique aspect of this case. And so I thought I'd share a couple of other things that really I don't think is generally known to the public. After the mid-June ruling, I left on my annual baseball trip, flew to New York City. Thursday night, I'm at the no longer there ESPN Zone restaurant at Times Square, having dinner with my friends. And all of a sudden I see my name being scrolled on ESPN about the ruling I just made. And you're sitting there going, really? And then I think my son gave me this. There was an article in the Canadian media that referred to the judge for the next 5 months as probably the most powerful man in professional sports. I have some athletic ability, but the only reason I got my name in Sports Illustrated was a Coyotes case. The media was desperate for an interview, and I told the clerk of the court, it's a violation of the judicial canons. It's not going to happen. Tell them no. Okay. And then my son calls me. Now he's a graduate of the same law school as I am, Redfield T-Baum Jr. And they found him, and he started giving interviews. I told him, I said, you do whatever you want, but don't talk to me beforehand about it. And then lastly, about 3 years after the case was over, the Canadian Bar Association annual meeting was one of the big hotels in Scottsdale, and they asked if I would come out and talk about this case. Sure, I'd be glad to. And as I was talking at some point, as I said earlier, I said something to the effect that I never understood the NHL's treatment of Wayne Gretzky. He's the GOAT. He's the greatest of all time for the NHL. And about that time, that's probably the biggest standing ovation I've ever gotten in my life from all the lawyers in Canada. So this case had so many unique overtones to it. It's hard to share with you everything that went on in that time from May 5th until roughly October 1st for the second ruling at the docket.
So we did actually we made the Wall Street Journal for one of our briefs because we included the Seinfeld defense as part of that. That was a little excerpt from a Seinfeld episode where Jerry wanted to return a coat, and the manager there says, why do you want to return it? He says, out of spite. I out of spite. And then the manager says, no, you can't return it for that reason. And so he says, well, then I don't like it. And he said, it's too late. You said spite. You can't return it. So that's effectively the same thing. They don't like PSE, and therefore they don't want us to be members of the NHL, no matter whether it's legitimate or not.
Yeah.
We'll consider anything else.
There were two reported decisions from the case. There were two hearings, and after the second hearing, it wound up, I think, getting settled in the sense that, from the debtor's perspective, they realized that they needed to walk away because the season was about to start, and the team really couldn't be in bankruptcy in this unsettled state by the time the season kind of kicked in. But and I forget which decision it was, Judge, there were two, both reported, but on the one, you had, nobody made an offer, so it went out to bid, it went out to auction, in the sense of noticing went out of the sale. And people had to bid based on, are you gonna keep it here? Are you gonna move it? And, so we could do that. The NHL was trying to say, first, let's just notice out to keep it here.
The Glendale only.
The Glendale only sale. And we said, no, because if you do that, if you do that, we don't have it and we've lost this time, given the time element. So I think eventually it's just kind of a notice, bring your bids. And there was a lot of tire kicking and people coming in.
And PSE's final bid, and part of its deal for Glendale, part of its offer to Glendale was to say, that we will close, it's December 31st of 2009, and you can keep playing the remainder of this season in Glendale, and then it will move after that.
But I mean, in response to the only offer being out there was the PSE bid, which was NHL was opposed to. The NHL did something that I understand had never done in its history before, or maybe since, which is the NHL essentially offered to buy the team, much like Major League Baseball did with the Expos, and where the league itself, which is just a combination of the owners. It's a cooperative in that sense. So they decided to make an offer to buy it, and their offer very specifically was where there was a credit bid element because NHL was a DIP lender, a debtor in possession financier, and they had a secured claim. So there was that, but then there was going to be cash. But the cash element of it was they chose specifically what creditors, unsecured creditors, were going to be paid. So it was the old legitimate versus illegitimate creditor type of dichotomy. You had a schedule. Schedule said the hot dog vendor, this person, that person, they're going to get paid. But then any of the Moyes related entities would not get paid. Gretzky's not going to get paid, et cetera. And so it went out, and that was the subject of a reported decision. And right around this time, Judge, Chrysler had just come through and been approved. And if you think about Chrysler, you had essentially in 30 days, the nationalization of a multi-billion-dollar company. And they pretty much did that in the sale. You're going to get paid. You're not going to get paid. I mean, the sale was essentially a plan, not even sub rosa. It was just a plan. And so I remember it was the NHL would argue, the judge did it in Chrysler. That's why you should be able to, allow our offer, even if we're allocating how money's going to go. And I do recall you saying something like, counsel, this is not Chrysler. I do remember something along those lines because it's kind of sui generis. But what are your thoughts about that, Judge? About that?
Well, if you remember, at the end there were two bids, PSAs, which for reasons we can discuss, I said I can't approve. I think it's open for PSA. Then there's the NHL bid, and it was said, I think, a little more subtly than this. But, if you want to buy it, you can buy it, but you can't control who gets paid and who doesn't get paid. And I can almost quote the last line of that ruling: the court's going to pass the sales puck, back to the NHL and see what they want to do. And I think the only reason that deal ultimately got approved is, I don't remember who Wayne Gretzky's lawyer was, but they got the consent of Wayne Gretzky for the NHL offer without Mr. Gretzky being paid anything. So Moyes and Gretzky were the illegitimate creditors, and all the other creditors were paid in full, and the deal closed.
Well,
Right,
Judge,
and remember too, when we talk about Mr. Gretzky, because his name keeps resurfacing today, what we're talking about is Mr. Gretzky getting paid from the bankruptcy estate.
Right.
I don't think any of us here know how Mr. Gretzky may have been dealt with outside of bankruptcy, but at least for purposes of this
He
case.
knows.
we don't.
Okay.
We both know. We both know how it was dealt with outside of
There's a funny sequel to the Chapter 11 case. I'm literally sitting with the chief district judge probably a year later. And he says something like, I think I ought to transfer this case to you. You kind of go, what case? And he says, well, there's litigation between the NHL, Moyes and the Moyes entities and Wayne Gretzky. And you handled all this, so I'm gonna pass it down to you. And it's the only report and recommendation I've written in my judicial career. It was a long one. And I don't remember exactly why, but I kind of stuck it to the NHL on Gretzky. And
Judge,
ordered that he should be paid. And I do know that that report and recommendation, as it does by statute, goes up to the district court. And I know at some point they paid Gretzky and he was gone. And ultimately that case was settled, but you talk about a super secret settlement. Beyond what happened with Gretzky, I don't know what the deal was. My friend,
I don't
Mr.
know.
Salerno,
I don't know.
his law firm represented the NHL. Mr. Maiden, my friend, represented the NHL, and I don't think any of us know the rest of the deal.
Judge, the way that lawsuit got transferred over to Judge Snow in the district court in Arizona was after the bankruptcy sale went through, and the way the NHL got around your concerns about allocating is they just went out and bought the claims. And so they just, which is fine, it's same way to get to this, it's a different way to get to the same result. They bought the claims at 100 cents on the dollar and then just reduced the purchase price accordingly, because the unsecured claims, other than the prior owners and Gretzky, were de minimis.
11.6 million, as I recall, something like that, $12 million.
Okay, I'll accept that. But then there was, as part of the owners getting the team, signed a guarantee of obligations. And the guarantee had subject to New York law, and they consented to New York State Court form. So the NHL sued within a month, maybe less, of the sale closing. The sale closed in November of 2009. I remember very specifically. Within a month of it closing, the NHL sued the owner on the guarantee in state court. The issue got kicked to district court on the basis that there was a federal question, which is how were these impacted by what had happened in the bankruptcy? And then they moved to change venue. So once it's in the district court, out to Arizona. And of course it goes to Judge Snow. And so it kind of came full circle. So it went from New York State Court, New York District Court in Arizona, referred down to bankruptcy court. So it wound up from whence it started, if you think about it. It was a very interesting circuitous route. But there was a settlement that was I literally have no idea what the settlement was, and no one is allowed to talk about it. And that's probably the best, to keep these things. But it is interesting. When you look at the alliance, I called it the unholy alliance between the NHL and the city of Glendale. It is very interesting because as part of the NHL purchase of the team, if you think about someone who would buy the team, there would normally be not only an assumption and assignment of the NHL contract, so to speak, because hard assets were not really, pucks and sticks. That's not what the issue was. But you'd also think there'd be an assumption and assignment of the city of Glendale lease, the arena lease, so that you'd have a place to play. So when the NHL became the owner, they didn't want to assume the other 20 plus years of the city of Glendale
Because they would want to move it.
Yeah, and so the NHL deal, which was agreed to with the city of Glendale and agreed to by us at that point, was that there was going to be a thing called a transition services agreement. So what the estate did is we didn't assume it, we didn't reject it. Everyone just pretends it's still in existence. And there was a period of time, I think a year or something like that, where they agreed, it didn't have to be assumed, it didn't have to, be rejected. And so it just rocked on and you paid the regular rent that was under there. And the NHL took over payments of the lease payments. And then at the end of that time, because we said we couldn't reject it before the end of that. And I think the NHL's thought was, we're going to have a new owner by the end of that, and then they'll figure out what they're going to do with the team. But they owned it for about 3 years, Alan? I think they owned it for,
I think it was 2 years.
Yeah, something like that.
Of trying to sell it to somebody else. And
Yeah.
Nobody else was willing to put in the money.
Yeah.
Because it was continuing to lose.
But and then the city of
There were interested buyers. And ultimately, they did find a buyer for the club.
Yeah, I mean, fair enough, they did. But then you got the situation where we rejected the lease after the time period was up, because that time we needed to close out the estate. And you can't, if you close it out without dealing with the lease, then there's this argument that it floats through the bankruptcy. We couldn't have that. We couldn't have that. And so we did reject it. But by that time, there had been this, I think, a 5-year deal. There had been some limited deal where the parties then spoke. And it was that agreement that the city subsequently repudiated by saying that whoever agreed to that had a conflict of interest, and therefore we're not bound by it. The city's not bound by it. And so I always found it ironic, I suppose, that during the course of the bankruptcy, the city of Glendale was saying the earth will spin off its axis if you reject this lease. I mean, it's a horrible thing. And then, you fast forward, and it wasn't even 10, 12 years like it is now. It was within 5 years of the bankruptcy being over. They said that deal we cut after the case was over, that we're not going to be bound by that deal. Yeah, and they got out. And so I always found that somewhat ironic, but it's just me.
Well, I think it's the easy answer is the Glendale location was an economic loser for whoever was running the Arizona Coyotes. And I do want to back up to one thing. The players in all professional sports do collective bargaining agreements. And so the irony is you have these athletes, baseball, who are making $30 and $40 million a year, who are just like the laborers at the car companies, same rights and obligations. So because of that collective bargaining agreement, the players of the Coyotes were never at risk of not being paid or somehow having their contracts rejected and renegotiated. And it's an odd facet of professional sports, but it's right there.
Yeah. Well, you do look at some other of the bankruptcy cases of professional sports teams. Pittsburgh Penguins, for example, Mario Lemieux, who wound up being the owner out of the bankruptcy, while they couldn't deal with his claim other than he had a big chunk of deferred compensation, much like in the Dodgers case, a huge creditor was A-Rod, was Alex Rodriguez, because, you read, oh, this person's making $20 million a year. And we think, oh, that's a nice paycheck every month or every, and of course it's all, a lot of it's deferred. So kind of the back. And that's how people, when they take the contract, yeah, but you also got to take the deferred compensation piece. And so the biggest creditor of the Dodgers was, I don't think it was Rodriguez, but one of the big names, same thing, Mario Lemieux. I don't think we had in the Coyotes any of these huge deferred. I don't recall that
they didn't spend any money on players.
Probably not, but I don't think we had any of these huge deferred contracts that were an issue. But it is another unusual thing. It's that you can't really reduce your labor force, labor being the players, because that is your product. That's your product. You just can't do it.
Yep.
We have a couple of questions from attendees, if you guys would like to
Fire away,
answer them.
fire away.
Okay, great. So the first one is, are you aware of any changes to the NHL charter that came from this or result of this case that would preclude the ability of another NHL team to file a Chapter 11 or the Canadian equivalent in the future?
Alan, why don't you answer that one?
The answer to that is I am not aware of any changes. So I don't know if they've thought about it. I don't know if they've done anything about it.
I'm sure they've thought about it.
I think the sports leagues between roughly the 8 NHL Chapter 11s, the Dodgers, one of the most valuable franchises in Major League Baseball, the Cubs, same comment, and the Rangers have recognized that they can't just say, you can't do it. You can make it a breach of the Constitution, but that's not enforceable under Section 365. So they don't like it. They don't want to live with it. They recognize it's a reality.
And I think you reflected that in one of your decisions, where you said that you can't treat a sports team differently. They don't have some automatic carve out from bankruptcy.
Yeah.
Was the antitrust adversary propose as a core or a non-core proceeding? Do you remember?
Well, I think it was a non-core related proceeding. And so, yeah, it was a non-core related proceeding, and that resolved itself as part of the overall resolution when the NHL bought the team. So that got released, got dismissed with releases, et cetera.
Would that have made a difference to you, Judge, if in fact that adversary had proceeded all the way through? I mean, I think that there was a motion for summary judgment that was filed, but if you had that kind of a litigation type ruling that was made.
The easy answer is, I don't know.
Mhm.
And you remember, I believe in the second opinion, I said something to the effect, I received this mountain of evidence about all of these issues. But you have to remember, this is all done in the administrative case under the 363, 365 motions. And so I'm not deciding antitrust rules. I'm just going to make some general comments. They're complex. Professional sport leagues don't fit well in the antitrust arena. What goes on in professional sports can't be a per se antitrust violation. And so all of those issues would be litigated in theory someday down the road. But I have no idea what the impact of that would have been. And you got to remember the time frame here. This case started May 5 and it basically ended, I think,
November 9 or something.
yeah, early November.
No, I know. This was the most intense 6 months of my life.
Yeah.
I looked at my timesheets, and I had 888 hours personally in that 6 months.
Yeah,
And
it's
that's
crazy.
in addition to hours of associates and others that I had.
But you
12,
know,
13 and 15-year-old kids at home. I mean, this was just an enormous strain.
I think there was an issue that came up. I don't remember if it was the first decision or the second decision, but there was an issue that came up in the context of selling the assets free and clear of the interests.
Right.
Interests being
exactly.
the membership rights,
Right.
the right to determine the owners and right to determine where
Correct.
those owners play home games. And the question was whether there was a bona fide dispute.
Exactly.
And I believe the decision that you made, Judge, was that the actual filing of the litigation didn't in and of itself create a bona fide dispute.
But you ultimately determined there was a bona fide dispute, but you didn't determine, I mean, what we were saying was the alternative was that there was deemed consent because the consent was not withheld, that it was withheld in bad faith.
I think in the June ruling, I concluded that for purpose of that ruling, there was a bona fide dispute.
Mhm.
I think it's important to emphasize the heart of the second decision denying PSE's request to assign and sell was under section 363E. And I love the introductory language. We all know how long section 363 is. Quote, notwithstanding any other provision of this section, the court has to prohibit or condition the sale so as to adequately protect the interests of the non-debtor in the property being sold. And I concluded, I felt the NHL had three interests, and I just didn't see any way I could adequately protect those interests by approving a sale to PSE and letting the team move to Hamilton.
But that was if, in fact, they would ultimately win, then you wouldn't be able to reverse it. But if, in fact, a decision had been made that there was deemed consent, that this was a proper sale to go through, then there wouldn't have been a reversal down the line. There wouldn't have been something to adequately protect in that way.
I understand your argument, but even accepting that, how do I adequately protect the relocation fee and rights of the
But
NHL?
that's by making a determination of the relocation fee. And you certainly had enough information about that
and-
with scads of
Yes,
experts.
and I think the range of opinions was something like 0 to over $100 million. And it was a few years later, but I do think it's fair to note that when the Las Vegas Golden Knights paid an expansion fee to the NHL, it was $500 million.
But that's not a relocation fee. That was an expansion fee.
You know, according to
They were not a team there.
according to the Ninth Circuit, I think that the functional equivalent.
But keep in mind, everyone, that when we filed the antitrust lawsuit as part of the initial filings, I don't think it was anyone's belief, given the compressed timeline we're all working on, that it was somehow going to be a final order on the antitrust lawsuit. We recognize that's just not possible. I mean, I don't care, rocket docket, whatever rocket docket you have, there's just no way. And so the concept was, there was enough to be able to say there was a bona fide dispute with respect to that. And this concept of you can't do it because the documents say you can't do it. That's what the documents say. And the argument that we made repeatedly was, if I have a deed, if I take title to property and it says you may not sell to Italian Americans, that's the restriction on the deed, because this is a restricted asset. And say, well, Judge, you wouldn't have to enforce that restriction because that would be violative of the law, anti-discrimination, et cetera. So we use that analogy, just that the lawsuit had to be on file, but it would have taken years. I mean, years. When would you, by the time you get done to the Supreme Court, which is where the NHL would take that? I mean, yeah.
I think just to try that, it's either in the bankruptcy court or the district court. That's a number of years.
Easy.
And we've kind of gotten away from questions, so I don't know if
We have one last question for you,
Okay.
Judge Baum, and then we have about 4 minutes to wrap up, so it should be perfect. If Glendale had accepted the 50 million offer from Ms. Freeman's client and supported PSE, do you think you would have decided differently from this anonymous attendee? I was in the court every day and I thought, maybe just a hunch, that you were not impressed with the NHL's arguments, but you were sympathetic to Glendale's arguments that they faced massive damages if the team left the state.
I'm not sure it would have changed it, because, all right, you buy off Glendale, you pay them $50 million, they withdraw their objection. You've still got the NHL and their three, who could be an owner, where you have to play, and whether you can relocate someplace or not. And to my knowledge, there's no case where an outsider has been able to force its way into a professional sports league through litigation. It's almost like they've got a veto. I know Ms. Freeman will argue about that, but you look at all the cases, and there's no court anywhere that I know of that says, yeah, you can do it.
Well, it comes back to, you have to comply with the criteria that are objective and reasonable criteria and do it in good faith. And I think the closest you come to that is that Rangers
case, yeah.
where the judge said, I will decide if I have to, but you have to be making your decisions in good faith. And if you're not, and that's where we were just saying, they're not making a decision in good faith, because all of the evidence we presented showed that Hamilton would make money for the league. It would be solid. It would be a really good place to.
I don't dispute any of that. That litigation was an existing owner, not a non-owner suing to get into the league.
But then you get back to, it's the decision not to let them in good faith, because this was a company, an entity that was approved in the past, and the reasons that were given, well, you didn't go through with the Predators acquisition. Well, you didn't go through with the Predators acquisition because that was a non-binding letter of intent that you decide not to go through, after making it very clear that we want to relocate if we can't get a new lease at an arena in Nashville, which had already rejected, which had already terminated the Nashville lease, and we'll try there, and if we can't, then we'll need to move, making it very clear and thinking we could do it, and then the decision was no, we're going to come in with all these restrictions and prevent it.
We'll hold that one for the next sports league.
But the bottom
case
line
there,
is,
huh?
there were legitimate reasons for all of the decisions that were then questioned.
Well, as I can tell you from the debtor's standpoint, the whole dust up with the city of Glendale, we always considered it a sideshow. It was another skirmish, but at the end of the day, the judge never had to decide whether we could reject or assume the lease with the city, because it obviously, based on the sale, it stayed there, and then you had the voluntary or the consensual transition. We just never saw it as the driving force.
It was pretty clear to me in 2009, Commissioner Bettman was going to stand arm in arm with the city of Glendale, because they spent a lot of money to build this new arena, And he's conscious of, well, if I turn my back on them, who's gonna build the next arena
Yeah.
for the NHL? That was pretty clear in 2009. And my, times have changed.
Yeah, true.
Well, I think we're at time, so we may get cut off in a minute. So I just want to thank all of you so much for doing this. I know that, you've probably had to do other panels like this over the last several years, but hopefully this was fun to all get together in the same room and see each other in person since we're all in Phoenix. And so thank you so much for your time today. Thank you so much,
Thanks
for
everybody,
having
for
us.
attending. We really appreciate it. We hope you enjoyed it. Have a great rest of your day.
Yeah, they roll the credits, this theme music, Thanks, Ed. This was fun.
Meatball,